Today we're highlighting some of Court TV's fastest verdicts of the year. Coming in at number 3 with just under 2 hours of jury deliberations, the car crash vigilante trial.
And when you got on the phone with 911, you stated that he had pulled the trigger?
Yes.
And what else did you state?
To her, I had told her that he had just pulled the trigger on my gun. And I remember kind of looking around and I noticed behind me that there was someone who was standing behind me, and I asked them if they seen everything, if they would stay to, you know, be a witness. And he was asking, like, if we were okay. He's like, are you okay? Is everything okay? And I told him, I mean, I am, but no, he's not.
Hannah Payne was sentenced to life with the possibility of parole plus 13 years after a jury found her guilty of fatally shooting a man during a traffic dispute. She was 21 years old at the time. Number 2 is the tortured son murder trial.
People of the state of Michigan versus Shanda Vander Ark, count 1, charging open murder involving the death of Timothy Ferguson. We find her guilty of first-degree felony murder. Count 2, first-degree child abuse. We find her guilty of first-degree child abuse.
Now, a jury deliberated for an hour and 29 minutes in that case before finding Shanda Vander Ark guilty of killing her teenage son with special needs.
The limited number of photos she had of her son were deemed too graphic to be released to the public. Timothy Ferguson was found dead and severely malnourished inside the family's home in 2022. Vander Ark's defense attorney said this case was difficult even for him.
And drum roll, please.
I 1986. This is the worst case I've ever handled. It's not even, I've handled cases with serial murders. This is the worst case I've ever handled. You do your job. The facts were terrible. The outcomes were worse. You do your job. You come in there, and your job is to represent this woman and to press for her point of view, and that's what you do. If you do that, and the prosecutor does that, and the jury does their end, and the judge does his end, justice gets done in the end, and that's the objective. Now comes the time where you have to sleep after the end. I mean, once you do all the intellectual stuff, the emotionality of it kicks in, and you got to sit down and you got to sleep with these facts and those images that are forever in my mind.
And number 1, give me a drum roll, please.
Yes.
The pregnant niece murder trial.
There will always be an element of my life that will be permanently missing. That element is Ayanna Sawyer. Our lives were so intertwined. Everywhere we went, we were asked if we were twins. In fact, you would rarely see one Sawyer sister without the other. However, now you will never see me or my sister together. With every accomplishment bringing great sadness, for every congratulations, the thought that I should not be my mother's first child to graduate, attend college, or move into an apartment crosses my mind. It's extremely difficult to step into my childhood bedroom and see one bed where there used to be 2.
That was the sister of Ayanna Sawyer at her killer's sentencing. The jury in this case deliberated for under 1 hour. The body of the 16-year-old victim was never found, but the jury still convicted her uncle of both her murder and the murder of her unborn child. According to police, he was the baby's father.
We, the jury, found the defendant guilty of first-degree murder as charged in the indictment. We find the defendant did actually possess and discharge a firearm during the commission of the offense.
Now, a judge ultimately sentenced Johnathan Quiles to 3 life sentences after a jury recommended life without parole. All right, let's bring in our guest, still with us, criminal defense attorney Jeffrey Wolf. All right, Jeffrey, I tried to sort of look and see what some of the similarities in these cases, and I mean, first and foremost, a lot of evidence, clearly. But I think the thing that jumped out at me was there wasn't any alternative. So when you have a defense, if you have somebody else you can possibly point the finger to give something for the jury to think about, those cases tend to take a little bit longer. None of these, well, there was any question who committed these crimes.
Yeah, I think that when you don't have reasonable doubt, you don't have anything to hang your hat on. And so alternative suspects are good. Bad police work is helpful for that. And these cases were just absent that. And put on top of that, that you had some pretty unsympathetic defendants testifying in number 3 and number 2. And they just testified terribly and did themselves a disservice. That's going to be a problem as well. The other commonality that you see in number 1 and number 2 is tragedy, is young people dying. And when young people die, juries are more apt to want to blame someone. And so when you put somebody in front of them worthy of blame, they're going to get it, and they're going to get it swiftly.
You know, I love that you pointed out 2 of them, the defendants testified, because Vander Ark's defense attorney, we actually were the ones that had an opportunity to speak with him. And one of the things that he also said was, listen, my client has a right to tell her story, to talk to the jury. She's innocent. She wants to tell this story. Well, or tell her version. In that case, she didn't intend to kill him, was her defense. And in doing that, it makes me question, Jeffrey, is there really ever a time that a defendant should advocate for their own self on the stand?
Yeah, there absolutely is, quite frankly. It is a unpopular opinion amongst defense lawyers. I think juries want to hear the why. I think they want to hear why you're not guilty, why you're being falsely accused, and they want to see you upset about it. It is human nature that if you were accused of something you didn't do, you get on that stand and say so. And so if your client can do it without perjuring themselves, if your client can do it without presenting in a horrible way, it's something that should be encouraged by defense lawyers and never discouraged if a client wants to do it, because it 100% is their constitutional right. So even if you think it's a terrible idea, you can't force your client to sit on that table and not take the stand. You can advise against it, but you shouldn't force that hand there, because it is their right. And quite frankly, there's nothing more persuasive, if they're good on the stand, than somebody standing up and saying, I didn't do it.
But you know, in the case of Hannah Payne, clearly I think she sort of sunk her own ship. I wasn't sure she needed to take the stand. I thought there was plenty of her on tape talking to police at the scene, which wasn't flattering to her, and maybe she felt like she needed to explain. But I think she sunk her own ship there. I wonder if that absolutely, I think you're right, but I think it really does work both ways, Jeffrey. If you're not good on the stand, boy, that's a tough one to rebound from.
100%. And the thing that was the problem for her was, you're right, there was so much of her already recorded that all she did when she took the stand was contradict herself and say things that weren't believable based on her own words being used against her. So yeah, it goes the other way too.
All right. Thank you so much for approaching the top of the hour to Jeffrey Wolf for being with us. I'm glad to be back with you today, Mike.
Yeah.